Greetings, 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 greetings. This is I, your King, King Clifford Jefferson, descendant of God for the fifth kind of man Jew, son of folk, of Jerusalem, on the reincarnation of Jesus Christ, which we call or identify with that image of Christ as King Edgar the Peaceful. I'm here again with another marvelous lesson. In lieu of the past four, or actually on behalf of all the other lectures that I ever did, this one I'm gonna bring it a little bit home to what's the issue that we're facing today in regards to the understanding about citizenship. All right, citizenship for all those who are here on this continent, what we call it America. All right, styled as the United States of America. We know that as it's told today, is based off a construct that goes back to what we call the Naturalization Act of 1790. All right, and we know that that was a model after the Plantation Act of 1740, which we're visited today. All right, in regards to citizenship, because everyone here falls under the guise of some type of citizenship. What type of citizenship is yet to be understood. All right, so bear with me. I won't be long-winded, but once again, I could be watching Martin Lawrence or playing with my dog. I mean, I can get the attention that I want without conversation. But yeah, I chose to speak to you because you are what's at stake in regards to understanding what's about to be undertaken by you by the events that are occurring. All right, you see, the rest of the world is experiencing these events, which we have yet, or you have yet to experience. So without further ado, let's get started. Today is September 28th, 2023, which is the birth year 2973. I greet you in the name of my ancestors, all the Africans and noble family, and with all things, I greet you in the name of the English Third Temple Church, which is the third temple that was spoken of through prophecy to be rebuilt. This represents the Christ Church or the bride of Christ. And if you're not in the church, if you're not considered part of the bride of Christ, and I represent that image of Christ, i.e., you are my bride. So I know who each and every one of you are because of your affiliation with the English Temple Church, which is your citizenship, which is not by what we call immigration or naturalization or what we call alienation, because your citizenship is inalienable. All right, is inalienable. So it's very important you to understand citizenship, which I'm about to break down to you today in regards to how it's out here and what we now call the United States of America. And you're going to hear from the head of state or chief officer of the head of state of the United States. And before there was the United States, there was the Confederate States. And those terms, United States and Confederate States, are synonymous according to law. If you don't know that, now you know or will know as a result of me bringing that clarity to you. All right. So whether you want to or not, or want to identify with or not, you have not had an informal nor formal introduction to your citizenship. All right, here in what we call North America, no matter what state you are. So if you had not had a formal introduction, here's your formal introduction. All right. Whether you want to agree with it or not, this is your formal introduction.
Welcome, my fellow Americans. First and foremost, I want to thank you for choosing us believing that America is worthy of your aspirations. Every immigrant comes to America from different circumstances and for different reasons, but you all have one thing in common: courage. The courage it takes to sacrifice and make this journey. The courage to leave your home, your lives, your loved ones, and come to a nation that is more than just a place, but rather an idea. An idea that where everyone is created equal, deserves to be treated equal. The idea that we have as a nation, and we can define America in one word: possibilities. Possibilities since its founding. That very idea has been nurtured, enriched, and advanced by the contributions, sacrifices, and dreams of immigrants like you, and immigrants like my own ancestors from Ireland, like generations of our fellow Americans. And today, you've earned a new title equal to that of an American president, the title I'm most proud of: citizen, citizen of the United States of America. I look forward to standing with you as you embrace your new rights and responsibilities, as you build your lives and legacies here. Generations have done before you in this great nation of immigrants. So welcome, my friends. Welcome, my fellow Americans. Welcome. May God bless you all, and may God bless the United States of America.
So you have had your formal introduction for all those who call themselves American citizens. And if you call yourself an American citizen, then you agree with the fact that you are an immigrant. All right. Because as he agreed that his ancestors were immigrants as well. So this is a nation of immigrants. When you immigrant, that means you immigrated, you migrated, you came from somewhere else. All right. You heard it out of your president's mouth. So whether you had the formal or informal, now you're actually being told of what it is that you were supposed to be told about your status here as what we call a United States American citizen. All right. There's your formal greeting. All right. Now, why is this important? Because the status of the citizenship under the formal greeting that you just got from the president, he's the father of the nation, or for whence under the status that you have on what they call a Part 2 Secretary trip. All right. We talked about that term many times. So write it down. Immigration. Bear with me for a second. Immigration. Immigration. Everybody see that? Immigration is the international movement of people to a destination country of which they are not natives, or which they do not possess citizenship in order to settle as a permanent resident or naturalized citizen. Once again, immigration is the international movement of people to a destination country of which they are not natives, of which they do not possess citizenship in order to settle as a permanent resident or a naturalized citizen. So the immigration to actually become a citizen here is based off the laws that govern citizenship, which brings you to what we call the Naturalization Act of what we call 1740. Let's visit that first. Plantation Act. Plantation Act referring to the colonies. You hear that, y'all? The colonies, the 13 colonies. Or the Naturalization Act of 1740. So the Naturalization Act and the Plantation Act of 1740 are one and the same. Are common names used for acts of the British Parliament under King George II. That was an official act titled Act for Naturalizing such foreign Protestants and others therein mentioned as are settled or shall settle in His Majesty's colonies in America. Okay, so this is the model for the Naturalization Act of 1790 for all citizens of the United States that President Biden was just referring to, and every other citizens who come over here as a result of what we call immigration. All right, so the Plantation Act of 1740, which is being continuum of the which is now a continuum through the Plantation Act of 1790. All right, let's visit that. This is common sense. Everybody should know this. The Naturalization Act of 1790 enacted March 26, 1790. All right. Was the law of the United States Congress that set the first uniform rules for granting United States citizenship by naturalization, not by being a national, but by naturalization. The law limited naturalization to free white persons, all right, of good character. A free white person of good character, thus excluding Native Americans, indentured servants, enslaved people, free black people, and later agents. Although free black people were allowed citizenship at the state level in many states through the 14th Amendment. Okay, so understand the importance of the Plantation Act, the Naturalization Act, and then the United States Act of 1790, which was modeled after the Plantation Act of 1740, which that means that if you wasn't included in that category as free white person, then you were a slave, i.e. a commodity, i.e. property. You must understand that because you have citizenship here by some way. Either it's not through the Naturalization Act. If it's not through that, that means that the only citizenship you have here is through the 14th Amendment because you have no other national laws to protect you there. You must understand that. All right. Okay. Native American indentured service enslaved people are free blacks people, which they assume that us fall in that classification, but we didn't classify as free white persons. All right. According to the what it meant at that time, at the time of the founding fathers. This was in pattern after the, as we said, the Plantation Act of 1740, which was the Naturalization Act, now called the Naturalization Act of 1790. Now, this was patterned for the new United States of America. The new United States of America. Before the United States of America, they were called the 13 Confederate States. All right. It was not a unitary state, it was just a Confederate state, now called the federal states. All right. Because all the 50 some odd states in the United States are now federal states under the federal jurisdiction. All right. Simple. The United States of America or USA or U.S.A. U.S.A. or USA, commonly known as the United States or U.S. or U.S. or America, is a country primarily located in North America, consists of 50 states, a federal district, 5 major unincorporated territories, 9 minor outlying islands, and 36 Indian reservations. Okay. Indigenous people have inhabited America for thousands of years. Beginning in 1607, British colonization led to the establishment of the 13 colonies, in which is now the eastern United States, not the western, the eastern. They clashed with the British crown over taxation and political representation, which led to the American Revolution. The United States declared independence on July 4, 1776, becoming the first nation state founded on Enlightenment principles of inalienable natural rights, consent, consent of the government, and liberal democracy. So how could you have inalienable rights when you not when you're an alien? Alien rights and inalienable rights only come the rights of your mother country. They don't come from some country that you're migrating to as an immigrant. That'd be violation of the nationals there. And we didn't was included in the Naturalization Act of any act by the British Parliament or the United States. So that means that we have rights that were protected that we were unaware of, which were unalienable, which were natural rights. And it was considered by the government under the unitary state or the sovereign state that was at play at that particular time at the in the time of the Confederacies. All right, at the time of the Confederacies. All right, you must understand that. That brings us to the Articles of Confederation. Very simple comprehension. Articles of Confederation. The Articles of Confederation contain the preamble, 13 articles for the 13 Confederate states, now 50, a conclusion, and a signatory section. The individual articles set the rules for current and future operations of the Confederation central government. Under the articles, the states retain sovereignty over all governmental functions not specifically relinquished to the National Congress, which was empowered to make war and peace, negotiate diplomatic and commercial agreements with foreign countries, and to resolve disputes between states. The document also stipulates that its provisions shall be inviolable, observed by every state in the Union, and shall be a perpetual one. Let's go up here. The Articles of Confederation, the Perpetual Union, was an agreement among those 13 states of the United States, formerly the 13 colonies, that served as the nation's first frame of government. All right, the first frame of government, which is still the acting government under Article 6 of the United States Constitution. It's still active. All right. So all those who are of my complexion, who have not dealt with this issue, need to deal with it right now. You need to choose, because you heard Biden, they're only concerned with immigrants. That's why you can't get the rights as immigrants get, because you're not an immigrant. You're a national here. They just took the nationality away from you through giving you identity to identity by way of you learning their taxes, to subscribing to their type of citizenship through naturalization. Because anything beats slavery, which we'll address in a second. We'll address that in a second, all right? It was debated by the Second Continental Congress at Independence Hall in Philadelphia between July 1776 and November 1770, and finally by the Congress on November 15, 1777. Right here. The articles concisely established, I hope that's the word, conspicuously established a weak central government. All right, a weak central government. So if it's a weak central government, it's not a sovereign government. It's not a sovereign government. Afforded it only those powers the former colony had recognized as belonging to the king. The king was governed under what we call a unitary state, and the Confederacy was function under what they call a central government, as you just read here. There was no federal government at play at this particular time. The document provided clearly written rules for how the state league of friendship, known as Perpetual Union, would be organized. This was created in 1776 and reinforced by the last draft of it, which came about in March 1st, 1781. All right. And we see that played out in Article 6 of the United States Constitution, which says, and I'll read it from the record. Article 6 of the United States Constitution establishes the laws and treaties of the United States made in accordance with it as the supreme law of the land, forbids a religious test as required for holding a governmental position, and holds that the United States, under the Constitution, responsible for the debt incurred by the United States under the Articles of Confederation. The Articles of Confederation was with the Treaty of Alliance. All right. That's what with the Treaty of Alliance. Let me just pull that up. I don't know why I didn't pull that up. Let me just pull that up just so we can reference that. As you can see, everyone. Treaty of Alliance between the United States and France, February 6, 1778. Everybody needs to pull that up. Everybody needs to pull that up. The Treaty of Alliance of 1778. All right, but let's just look at it from Wikipedia. I just want a brief, short description of what it was talking about. Treaty of Alliance. Treaty of Alliance, also known as the Franco Alliance, was a defensive alliance between the Kingdom of France and the United States formed amid the American Revolutionary War and, with Great Britain. It was signed by the delegates of King Louis XVI and the Second Continental Congress in Paris on February 6, 1778, along with the Treaty of Amity and Commerce, and a secret clause provided for the entry of other European allies. Together, these instruments are sometimes known as the Franco-American Alliance or the Treaty Alliance. These agreements mark the official entry of the United States on the world stage and formalized French recognition and support of U.S. independence that was to be decisive in America's revolution. All right. So the Treaty of Morocco, Treaty of Amity and Commerce that was made with Great Britain are irrelevant because France and Spain had jurisdiction over here in North America before the British ever did. Okay. That goes back to the 14th century, if people know their history. But let's move forward. So we're dealing with citizenship. All right. We know citizenship in North America is only based off the Naturalization Act, which did not include us classified as the term Negro Black cousin Ethiopia. All right. It did not include us. That's very, very, very important. You know what I'm saying? Because we know that citizenship here was based off the status of the mother. And the status of the mother is based off a legal a term called partus sequitur via trim. All right. Partus sequitur via trim. We see that in the Dred Scott case. Hold that thought for a minute. All right. Let's see. Partus sequitur via trim. This is the status of the mother. All right. This is when we became bastards. All right. This is when we became bastards. We lost our right to inheritance because we became what we call, or under the legal term, bastards. Let's review that history real quick. Bastard goes back to William the Conqueror. All those immigrants who immigrated with them were considered bastards. Part two, secretary, beard trim. That which is born follows the womb. You hear that? That which is born follows the womb. Also, part two was a legal doctrine passed in the colonial Virginia in 1662 and other English crown colonies in Americas, which defined the legal status of children born there. That's a lie. That was not English crown colonies. That were British crown colonies operating under the English crown. English did not enslave their own. We see that in Somerset versus Stewart, which we're visiting in a second, as authorized by the King's Bench. So whoever wrote this don't know what they're talking about. All right. You have to be able to read behind the clues. All right. Uh, the doctrine mandated that children of slaves' mothers would inherit the legal status of their mother. As such, will be born into slavery. The legal doctrine, part two, Secretary of Trim, was derived from the Roman civil law, specifically the portions concerning slavery and personal property, chattel, as well as the common law of personal property. All right. Common law of personal property, i.e., commodities. Let's find an example. We know Dred Scott was an example. All right. Can we see in the case with Dred Scott? I had a part where it was at. In this second, just find it. All right. This is Dred Scott. It says, I consider the assumption which lies at the basis of this theory to be unsound, not in just sense, and when properly understood, but in the sense which has been attached to it. That assumption, that assumption in that territory ceded by France is required for the equal benefit of all citizens of the United States. So they ain't talking about British, he's talking about France. I agree to the position, but it was acquired for the benefit in their collective, not their individual capacities. It was acquired for the benefit as an organized political society subsisting as the people of the United States and under the Constitution of the United States to be administered justly and impartially. As nearly as possible for the equal benefit for every individual citizen. All right, not an immigrant, not an immigrant, because immigrant migrated here for rights that was already here being protecting their own citizens. All right, and we're dealing with the Dred Scott case. Dred Scott case can be considered an immigrant or a citizen under the Naturalization Act of 1790, nor was that was under the Naturalization Act or the Plantation Act of 1740, because they were dealing with immigrants. Dred Scott was not an immigrant. He was just subject to a Scottish king, all right, who enslaved us under the Constitution of the United States to be administered justly and impartially and as nearly as possible for the equal benefit of every individual according to the best judgment and discretion of Congress, to whose power as the legislator of the nation which acquired it, The people of the United States have committed its administration. Whatever individual claims may be founded on local circumstances or section different of conditions cannot, in my opinion, be recognized in this court without arrogating to the judicial branch of the government powers not committed to it, and which, with all the unaffected respect I feel for it when acting in a proper spirit, I do not think it is fitted. It's fitted to will. Hold on one second. Nor in my judgment will the position that a prohibition to bring slaves into a territory deprive anyone of his property without due process of law for examination. It must be remembered that the restrictions on the legislative power is not peculiar to the Constitution of the United States. It was borrowed from the Magna Carta. It was brought to America by our ancestors as part of their inherited liberty and has existed in all states, usually in the very words of the Great Charter. It existed in every political community in America in 1787. Did y'all hear that? In 1787, when the ordinance prohibiting slavery north and west of Ohio was passed, and its prohibition of slavery in territories in 1820 violated these principles of Magna Carta. The ordinance of 1787 also violated it. And what power had, I do not say the Congress of the Confederation alone, but the legislative agenda of the legislature of any and all other states of the Confederacy to consent to such a violation. You hear that? The people of the states have conferred no such power. I think I may at least say if Congress did then violate the Magna Carta by the ordinance, no one discovered that violation. You hear that? If Congress did violation of the Magna Carta, no one has discovered that violation until now. Until now. How I know that? Let's qualify this. All right. Somerset versus Stewart. By the King's Bench. Somerset versus Stewart. We know Stewart is the name going back to the kings of the House of Stewart, was a judgment of the English courts of the King's Bench in 1772, relating to the right of enslaved persons on English soil not to be forcibly removed from the country and sent to Jamaica for sale. Lord Mansfield decided that the state of slavery of such nature that it is incapable of being introduced on any reason, moral or political, but only by a positive law. Now, there was a quote in Dred Scott versus Sandford. I'm gonna take a second and see if I can locate it. If not, let's see. Let's see. Give me 1 second. I think I just seen it. Here we go. Okay, here we go. All right, I'm good. I'm good. Now we just read, and I'm gonna lose that. And Somerset versus Stewart. The state of slavery of such a nature that is incapable of being introduced on any reason, moral or political, but only by a positive law, which preserves it, which preserves is for as long after the reason, occasion, and time itself from which it was created is erased from memory. it is so odious that nothing can be suffered to support it but positive law. Whatever inconveniences therefore may follow from the decision, I cannot say this case is allowed or approved by the laws of England, and therefore the blacks must be discharged. All right, the blacks must be discharged. If you adopt a law contrary to that of the Magna Carta, which protected people identified by the characteristics as termed black, then you are violating the law. Why? Because that's only sanctioned by positive law, and positive law is municipal law, and we are subject to municipal law. How we know it? Let's see what Dred Scott said in Dred Scott versus Sandford. It says here, slavery is sanctioned by the laws of the state, and the rights to hold them under our municipal regulation is unquestionable. But we view this as a right existing by positive law of a municipal character without foundation in law of nature or the unwritten common law. You hear that? Unwritten common law. So we know that common law is written, that's written is where the common law stops because it becomes time out of mind. When the people who were the common law was being used by ain't there no more, they start writing the common law, which now become case law, which you call stare dicey. That is not common law. Let's review that. Smith versus Alabama. Everybody look at us. Smith versus Alabama, 1888 case. There is no common law of the United States in the sense of a national customary law distinct from the common law of England, as adopted by the several states, each for itself, apply as its local law, and subject to such alteration as may be provided by its own statute. So positive law is unconstitutional in the United States as well as in the laws of the state. The King's Bench qualified it. Smith versus Alabama qualified it because the Magna Carta sanctioned it. Y'all better hear me. All those who call themselves of a darker complexion, y'all better recognize what's going on. A determination is given in a given case of what that law is may be different in the courts of the United States from that which prevails in the judicial tribunal of a particular state. This arises from the circumstances that the court of the United States, in cases within their jurisdiction where they are called upon to administer the law of the state in which they sit, or by which the transaction is governed, exercise an independent though concurrent jurisdiction, are required to ascertain and declare the law according to their own judgment. This is illustrated by the case of Rebel Company versus Lockwood, where the common law prevailing in the state of New York is reference to the liabilities of common carriers for the negligence received of different interpretation from that place upon it by the judicial tribunals of that state. All right. So we understand, as it said in Pittsburgh versus Alabama, there's only one common law, and that's the common law of England. All right. The only other common law that you could call stare dicey is that which is being practiced today, which has nothing to do with common law as Smith versus Alabama, because according to the common law, as it originated, was originated with the English people. All right. So if you're not an English people, that means that they ain't got to apply common law to you based off how it was used based off the people at that particular time. Let's find some examples of that. All right. Let's find some examples of that. Okay, go ahead. Ahmad Hassan, dealing with citizenship. All right. Because he immigrated to the United States. And we know immigration deals with somebody leaving their own country and coming to another country and wanting rights. All right. Ineligible rights at that. All right. So to summarize, as the court said in this matter, To summarize the approach which must be followed in deciding whether a particular person, that means everybody who watches this video and everybody who should be watching this video and everybody who ain't watching this video should be applying for citizenship, is a white person within the meaning of the statute as interpreted by the Supreme Court. It is necessary to determine the first a particular group or racial subdivision to which the individual belongs. All right. In practical effect, proof of this fact is a matter of genealogy. All right. Genealogy. The Naturalization Act had nothing to do with the genealogy or ethnicity. All right. Nor do immigration. Those who immigrate here. It has nothing to do with genealogy, ethnicity. It's based off the requirement being allowed by those who are in supreme, which falls in the classification of free white person on the Naturalization Act, which we as so-called Negro, Black, color, Ethiopian didn't classify as because we're still categorized under our complexion, which Dred Scott under that complexion fell under the laws of slavery. All right, they fell under the laws what we call slavery. We see here it goes on to say that an individual who presents an aberration for the color of skin of the group of which he's a member, such as a light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon, does not thereby acquire a different status, such as a light-skinned does not thereby acquire a different status under the act from other members of this group. This is the reason why we as Anglo-Saxon Berbers had to reestablish ourselves not under the classification as the majority of our people under this characteristics, which is facade are as dark skin or black, but under the requirement based off the first test, which is genealogy and ethnicity, going back to such a description as they said Anglo-Saxon. Because Anglo-Saxon, the original people of Anglo-Saxon goes back to those of what we call what is called Cheddar Grove. And Cheddar Grove is in Somerset. We know the Jews, the term Jew or the surname Jew comes from Somerset. And we know the word Jew goes back to those going back to time immemorial. And we know time immemorial goes back to that in English law, 1189. 1189 deals with the sons and the descendants of Richard I. And we know that when the Jews were expelled and went on this crusade, which we see as a modern term for the word immigrant, you know what I'm saying? Because we're assumed to be immigrating from somewhere else when the nationality, we're actually home. All right? They're trying to find out where we come from when you are actually home because they gave you an example of who a dark-skinned person can prove as a part of part of a society as Anglo-Saxon, but you first must prove that genealogy. You must prove that test. We prove that test. We are declared to be Anglo-Saxon Berbers. All right? So it says, of course, when an individual applying for citizenship has a skin of a different color than is a usual for a member of a group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of proving genealogy that he is, in fact, a member. Citizenship in North America, as Biden just said, is not based off the genealogy test. The nation that North America was founded on was based off any nationality test. All right? Y'all all must understand that. After an individual has been traced to its group, the second question which the court must answer is whether the members of the group as a whole are a white person as Congress understood it in the terms of 1790, when it first enacted in the statute. In deciding this later question, the test is now how the group in question will be classified by ethnologists who have made a study of racial origin, but rather what group of people then living in 1790 with the characteristics then existing were intended by the Congress to be classified as white persons. Dred Scott did not fit that description. Okay? He did not fit that description. Applying these principles of the court finds that the petitioner is an Arab, and the Arabs are not white person within the meaning of the act. Nor did Dred Scott fit that description, nor do we fit that description, because that is not our nationality, because America does not deal with nationalization. Their understanding of nationalization is naturalization, and naturalization deals with immigration, and immigration deals with immigrant, and immigrant deals with a migrant, which makes you an alien. I don't know how simple to say that. All right. If you don't believe that, let's get some more clarification. We already see it in Dred Scott versus Sandford, as we see as well in the Somerset versus Stewart case, the case heard by the King's Bench, that the only way that slavery can still exist is through positive law. All right. And positive law is municipal law. Municipal law is laws that violate the laws of the government, as we've seen in the Constitution. All right. Because Smith versus Alabama says all the states in the United States adopted the common law of England. And the only common law of England is that which is adopted by Let's go ahead. Let's just see. Let's just see. Here we go. Yeah. United States Constitution, New Jersey's Constitution, July 4th, 1776. All right. Article 22, that the common law of England, as well as so much of the statute law as have been hereto practiced in this colony, should still remain in force until they should be altered by the future laws of the legislature. Such parts are only expected as are repugnant to the rights and privileges contained in this charter, and that the estimable right to a trial by jury should remain confirmed as part of the law of this colony without repeal forever. Article 32. Provided always and its true intent and the meaning of that Congress that if a reconciliation between Great Britain and these colonies shall take place and the latter be taken under the protection of the government of the Crown of Britain, this charter shall be null and void, otherwise remain firm and inviolable. How do we know that? Under Article 6 of the United States, Article 6 of the United States Constitution, pursuant to the Articles of Confederation. Let's review that. I think we did do that. I'm not going to go through that again. Let's do Article 6. Article 6. Article 6 of the United States Constitution establishes the laws and treaties of the United States made in accordance with it as supreme law of the land, forbids the religious test as required for the holding of government positions, holds that the United States under the Constitution responsible for debts incurred by the United States under the Articles of Confederation. All right, so we see that. Let's go here. So if you're dealing with citizenship in North America, and you're saying you're not an immigrant, you first must understand what an immigrant is, as we read before. Immigration is the international move of people to the destination country in which they are not natives or where they do not possess citizenship in order to settle as a permanent resident or a naturalized citizen. So if you're a naturalized citizen, then you fall under the Naturalization Act of 1790. But Black people, Negroes, Black, colored, and Ethiopian cannot fall under the classification of citizenship. Why is that so? I'm trying to show you. I'm proving it that you are a national. We've seen that in Imre versus Ahmad versus Hassan, and they gave the first month proof through ethnicity and genealogy. All right, and they gave an example: a dark-skinned Anglo-Saxon. If you're saying you're an Anglo-Saxon, you no matter what skin color you are, you first must prove that you are a part of that group. They're saying they're not because their status here in North America is based off naturalization. Even though Anglo-Saxon was under the authority of what we call England. All right, let's prove it. Chief Judge Taney. Chief Judge Taney, the same one who ruled in Dred Scott versus Sandford. You know, Dred Scott versus Sandford ruled that Dred Scott was not a naturalized citizen. If Dred Scott would have raised the argument about being him a subject of the crown, he'd prevail because you know that The court knew that Dred Scott was being held up under the municipal law, i.e., positive law, which was contrary to those laws that protect the English subjects as citizens. That was in the Magna Carta for all English subjects. All right, for all English subjects, right? Because they were the property of the crown. All right, they was not under the jurisdiction under parental patriarch of the Attorney General of the state. All right, elected by the president. Why? Because that was under Part 2 Secretary, under the statute of the mother. When you were protected by the father, you come under what they call parental patriarch, contrary to Part 2 Secretary of Trent. Let's qualify it. Chief Judge Taney said, how many of your leaders can show you this? How many of your teachers can show you this? Chief Judge Taney, the one who ruled in the Dred Scott decision, to somebody who looked just like you. Dred Scott didn't know he was an Anglo-Saxon Berber. He just knew he had his skin color. And he was trying to fit in some particular groups. You are all trying to fit in the group by having not established the first test. You can't fit in the group based off the second test because they disqualify you from that group based off the second test requirement. The meaning of the intent of Congress. All right. Chief Cheney delivered the opinion to the court. This case was fully argued at the last term, but it was not then decided. Because the important principle involved in it made it proper that the case should be heard and determined by a full court, and that some of the justices were not present at the former hearing, and re-argument was ordered. In pursuance of this order, it has been again elaborately discussed by counsel and have been carefully considered by the court, and I am instructed to deliver the opinion. You hear this? The question before us arises upon the action of the judgment instituted by the defendant in error, who is the plaintiff in the court below, to recover 100 acres of land covered with water situated in the township of Perth Ample, which we are now, which means that this land belongs to the crown. Intel. Crown land is Intel land, all right, which I'm making a claim on your behalf, all right? Let's go to the meat of it, all right? The purpose and intent of this case. It says right here, Chief Judge Cheney said this, the right of the king to make this grant with all its prerogative and powers of government cannot at this day be questioned. We know when kings give a charter, that's a grant, and a grant is a letter patent, which is open and closed, and it denotes to the terms and conditions which are incumbent upon the grantee. All right, and the grantee only owns it fee and simple. All right, you only got fee and simple, fee and defeasible, and life estates. All right, those are only estates that the United States can grant, not guaranteed, only grant. But in order to enable us to determine the nature and extent to the interest which is conveyed to the duke, it is proper to inquire into the character of the right claimed by the British Crown and the country discovered by its subjects on this continent, and the principles upon which it was parceled out as granted. As I said, you only got a parcel estate, all right? Not a allodial estate, a parcel of estate. That means you got a real estate. Real estate is only a part of a state, a parcel of land. Whether you want to call it partial or whether you want to call it parcel, it makes no difference to me. Why? Because all land is allodial under the crown, because it's intel, and the land can't be separated by the crown and the king who personifies the crown. And in this case, proves it. The English possession in America were not claimed by right of conquest. You all better listen, but by right of discovery. So when you do your right of discovery, that's what we call prescription by what we call easement, right? You only claim to be a sovereign without being contested by the true sovereign until this day. I'm contesting it now. I don't care if you the president. I don't care if you somebody who got a mortgage. I don't care if somebody who works as a broker. I'm challenging all things from this point on. And English possession in America were not claimed by the right of conquest, but right by discovery. And we know discovery deals with the right of discovery or right of conquest. For according to this principle of international law as understood by the civilized power of Europe, the Indian tribes in the New World were regarded as mere temporary occupants of the soil, and the absolute right of the property and dominion were held to belong to the European nation by which any particular portion of the country was first discovered. All right? Whatever forbearance may have been sometimes practiced toward the unfortunate aborigines, either from humanity or policy, yet the territory they occupied was disposed of by the government of Europe as their pleasure, as if it had been found without inhabitants. The grant to Duke of York, therefore, was not of lands won by the sword, nor were the government of laws he was authorized to establish intended for conquered people. You hear that? The country mentioned in the letter patent was held by the king and his public and his regal character, i.e., jure regalia. Look that word up. Jure regalia, and look up the word jure regalia, and look up the word. What's the other word? Jure regalia. It's another time it comes to me. All right. Trust for them. The discoveries made by persons acting under the authority of the government were for the benefit of the nation and the crown. According to the principles of the British Constitution, was the proper organ to dispose of the public domain, and upon these principles rest various characters and grants of territories made on this continent. The doctrine upon this subject is clearly stated in the case Johnson versus McIntosh. In this case, the court, after stating in it to be the principle of universal law that uninhabited country, if discovered by a number of individuals who owe no allegiance to any government, becomes the property of the discoverer, proceeded to say that if the discovery be made and possesses take under the authority of an existing government which acknowledged by the immigrants, it is supposed to be equally well settled that discovery is made for the benefit of the whole nation, and the vacant soil is to be disposed of by the organ of the government which has the constitutional power to dispose of the natural domain, i.e., this is what they're using now. All right, because we know that when there's no heirs and when there's no heirs, that means that the property falls into escheatment as a result of what we call interstate, which means that ain't no heir to claim the land. So if it falls in the escheat, then it falls under the crown. We see that and represented by the Attorney General in State versus Standard Oil Company, which was ruled by the Rockefellers, which is nothing more than a monopoly, like each and every one you are. You're nothing more than a monopoly. And as a result of that, according to the theory of the British Crown, British Constitution, all vacant lands are vested in the Crown as representation representing the nation, and the exclusive power to grant them is admitted to reside in the Crown as a branch of a royal prerogative, i.e., jure regalia. It has been already shown. It has already been shown that this principle was fully recognized in America as in the islands of Great Britain. This being the principles upon which the charge in question was founded, by which ruled out it to be construed. Rules out it to be construed. We do not propose to meddle with the point which was very much discussed at the bar at the power as to the power of the king since the Magna Carta to grant to a subject a portion of soil covered by the navigational waters of the kingdom, so as to give him an immediate and exclusive right of fish feed either for the shellfish or floating fish within the limits of his grant. The question is not for free from doubt that the authorities referred to in the English books cannot perhaps be altogether reconciled. But from the opinions expressed by the justice of the court of the king's bench in the case, just as we've seen in Somerset versus Stewart, the question must be regarded as settled in England against the rights of the king, since the Magna Carta, to make such a grant. The point does not, however, arise in this case unless it shall first be decided that in the grant of Duke of York, the king intended to sever the bottoms of the navigational waters from the prerogative power of the government conferred from the same charter, and to convert them into mere franchises in the hands of a subject, to be held and used as his private property. And we the more willingly forbear to express an opinion of this subject because it has ceased to be a matter of much interest of the United States. I wonder why. For when the revolution took place, the people of each state became themselves sovereign, and in that character hold an absolute right to all the navigational waters and the soils under them for their own common use, subject only to the right since surrendered by the Constitution to the general government. A grant made by the authority must therefore manifestly be tried and determined by a different principle from those which apply to the grants of the British Crown. When the title is held by a single individual in trust for the whole nation, i.e., corporation so. Neither is it necessary to examine the many cases which have been cited in the argument on both sides to show the degree of strictness which grants of the king are to be construed. The decision of authorities referred to apply more properly to a grant of some prerogative right to an individual to be held by him as a franchise, and which is intended to become the private property in his hands. The dominions and properties, the navigational waters, and the lands under them being held by the king as a public trust, the grant to an individual of an exclusive fishery and a portion of it is so in so much taken from the common fund and trust to his care for the common benefit. In such cases, whatever does not pass by grant shall remain in the crown for the benefit and advantage of the whole community. Grants of this description are therefore construed strictly, and it will not be presumed that he intended to part from any portion of the public domain unless clear and special words are used to denote it. But in the case before us, the rivers, bays, arms of the sea, and all prerogative rights within the limits of the charter undoubtedly passed to the Duke of York and were intended to pass except those saved in the letter pass. Those words used evidently show these intentions, and there is no room, therefore, for the application of the rule above mentioned. All right, let's qualify this more. Let's go to state versus parson. And modern treatment signifies a falling apart to the sovereign for want of an owner, i.e., all my brothers and sisters are out there, you don't have a nation to claim you. So you're a property of somebody else under the Naturalization Act or the Declaration of Citizens by the state through their institution of the municipal law, i.e., called positive law, which Dred Scott found himself in this situation. And I'm going to give you another example of the same situation where somebody under the characteristics or the classification as Negro, black, colored, Ethiopian sought refuge in England, and he got it. All right, in the 18th century. All right, it says that a modern usage is signifies the falling of property to sovereign for one of an owner, as this category embraces not only property which has no other owner, but also property whose owner whereabouts is unknown. We're talking about your father. Talking about your fathers out there, where your children, they're considered bastards. When they are considered bastards, they're considered immigrants. All right. Now you have no estate because now they fall under the authority of what we call the state. All right. It says, under the common law of England, estates came to be classified as another branch of the king's ordinary revenue. See Blackstone's commentaries. What was originally an instance of tenure is now an instance of sovereignty. The doctrine of estate at the early common law operative only upon that which was the subject of tenure, since it related to the reversionary right of the lord to take for want of a tenant, was eventually extended to include personal property, intangible and intangible. The principle was that the right to take this which belonged to no one appertained to the king as jure regale. You hear that? Jure regalia and radical title. Look up the word radical title. Radical title refers to the territories that were claimed by the crown, i.e., overseas possession, i.e., the 13 colonies. Jure regalia and radical title. Look it up. It says the crown stepped in to take the property because it is vacant. Property described as bona vacantia is taken and assumed by the state as its own. Property of this class falls to the crown as a matter of rights and the exercise of its sovereign power. So there you see it here. It says here, in personal estates which are allodial by law, the king is last heir where there is no kin. So that means that if you were considered property, i.e., Dred Scott, and all those who are considered under the jurisdiction as naturalized citizens of the state, you are state property because you got your right from them. Prior to that, you had no right, but you abandoned your right, and abandoning rights is a result of what we call, what's the term? Treason. Now, a bill of attainders can be, or be a bill of attainders, which are attainders, can be applied to you for violating the laws that they give you because they become your master. All right, very simple. Let's find another case. Henry Box Brown. Anybody ever heard of Henry Box Brown? Pull it up on your computer. Pull that name up. I want to give a shout out to one of the comments that were given by one of the individuals who were being the channel when I made the call for anyone who has the courage to step out there and, reveal these truths that I'm revealing. And she or they or he replied that there is none. Now she's or he or they are faithfully watching the channel, and they made a remark that there is none. So, thank you for the courage to actually say that, because, this takes a lot of work, because those who claim to be doing the work apparently are not doing the work. You know what I'm saying? They haven't made one attempt to actually deal with the agenda on rights pertaining to those citizens should have, which is inalienable rights, not natural rights that were given to you as a result of a contract or agreement. If you do this, we'll do this. You know what I'm saying? You see it, and now it's a problem now because as we see the abundance of immigration that's going on here in North America, it contradicts the policies, the laws in regards to what the Naturalization Act 1790 actually stood for, as well as the 1740 Naturalization Act actually established, because everybody's being included except those who were classified under the meaning of intent in Congress as free white persons. You got everybody coming over there, but still we can't be categorized as that, even though everybody else is, who are not even citizens here. We were born here and we still can't meet the bar. We still came into the bar. Why? Because we set the bar. All right. How we know that? Henry Box Brown proves it. Henry Box Brown, 1850 to 1897. All right. Same time as Dred Scott. All right. Same time era as Dred Scott. All right. Henry Box Brown was a 19th century Virginia slave who escaped to freedom at the age of 33 by arranging to have himself mailed in a wooden crate in 1849 to abolitionists in Philadelphia, Pennsylvania. All right, Pennsylvania was a slave state. It was a slave state. Actually, y'all see this. I don't just be up here talking for nothing. Look at the surname Brown. From England. He was being enslaved by the Scotland and Ireland because Scotland and Ireland united with England in 1707 and 1801. So it's the Irish and Scottish enslaved the English descendant, i.e., Dred Scott, i.e., what's his name, Mr. Brown, Henry Box Brown. All right, the Brown family name is thought to be a Norman origin. Norman origin deals with the time of the Jews who were came in to England. We know that. Hold on 1 second. They came into England, and we know that they amalgamated with us and our families. Hold on. Amalgamated with our families, and you can see, the Fleur de Lis, etc. All right. So we see that the name springs from similar roots to Old English, Old Norse, Old French, Old German, blah, 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 blah. What we see is this individual who carries the surname Brown, which a lot of you carry the surname Brown as well. So this will be a good time to look at his case. You know what I'm saying? And find out why he was searching for freedom. All right. It says Brown was first. We know here in North America, if you didn't fit the classification of naturalization, then you was a slave. All right? You was a slave. You was a slave and you still is. Brown was first married to a fellow slave named Nancy. but their marriage was not recognized legally. They had 3 children born into slavery under Part 2 Secretary Beard-Trim principle. You hear that? Where children born to enslaved women were themselves enslaved. Brown was hired out by his master in Richmond, Virginia, and worked in tobacco factory. He rented a house where he and his wife lived with their children. We'll go further. With the help of J.C.A. Smith, a free black man, and a sympathetic white shoemaker named Samuel A. Smith, no relation, Brown devised a plan to have himself shipped to a box to a free state and Adams Express company known for the confidentiality and efficiency. Let me move further. Find it. Okay. Right here. After the passage of the federal laws of 1850, we had 2 federal laws. Federal laws of 1793 and federal laws of 1890, all passed by the United States. I better understand what I'm talking about. All passed by the United States. But we read that we were free people. All right? We were in the soil. We were on free people. This was the crown land. So the only protection you got was from the crown. All right? But you had to prove that. We can prove that because church and state was separated here. So there's no way the crown can have power authority as a result of the overthrowing of the province of New Jersey. All right, which was under the authority of the crown. That's why New Jersey is very important because we see in Article 30 what was it, 23, that's the true intention of the charter for reconciliation with Great Britain. All right, the English crown under the common law of England. But they went away from the common law of England because they don't know what the hell the common law is. All right. So it says after passage of the Fugitive Slave Act of 1850, which required cooperation from law enforcement officials to capture refugee slaves even in free states, Brown moved to England for safety as he had become a known public figure. He toured Britain with his anti-slavery paranoia for the next 10 years, performing several hundred times a year to earn a living. Brown also entered the British show circuit for 25 years until 1875, after leaving the abolitionist circuit following the start of the American Civil War. So here is this Brown traveling, moving in and out through England free as a free man, but can do it in the free states as free people. That should tell everybody something because why? He still didn't understand the power and authority that Part 2 Secretary Beard-Trim had. All right, let's read that real quick. Okay. Background of Part 2 Secretary. In 1619, a group of 20 and odd Negroes were landed in the colonial Virginia, marked the beginning of the importation of Africans into England colonies, into continental North America. Hear that? Into England colonies, but the people at that time were not under English kings, they were under British kings, enslaving the English subjects, all right? Because there is no English king there. Y'all have to understand the clarity of that. It said, so if what's his name, what's the name? Henry Box Brown fled to England. That means England was here. You see it right there. They had been captured from Portuguese slaves and Portuguese having begun the Atlantic slave trade a century earlier. During the colonial era, English colonial administration struggled to determine the status of the children born in the colony, or where their birth were the product of a union between an English subject and a foreigner, or entirely between foreigners. Did y'all hear that? Read that again. In 1619, a group of 22 odd Negroes were landed in the colony of Virginia, marking the beginning of the importation of Americans into England colonies and continental North America. They had been captured from the Portuguese slavers. The Portuguese having begun the Atlantic slave trade a century earlier. During the colonial era, English colonial administration struggled to determine the status of the children born in the colonies where their birth were the product of a union between an English subject and a foreigner, or entirely between foreigners. English common law mandated, you hear that? English common law mandated that the legal place or status of an English subject children was based on that of their father as the head of the household, known as paterfamilias. Common law stipulated that men were legally required to acknowledge their bastard children in addition to their legal ones and give them food and shelter, while they also had a right to put their children to work or hire them out, taking any earnings or arranging an apprenticeship or a indenture so that they could become self-supporting adults. This is why the Attorney General has become Parental patriarch. That's why he has become the father of the children, not you no longer, because your status is the same status of that of a child under Part 2, Secretary of being Trent. All right, y'all better understand this. This dude, you've been labeled as bastard children. If you're a bastard children, that means that you're illegitimate. Let's reveal that. Illegitimate. Colonial America. Colonial America bastardy laws were laws, statutes, or other legal proceedings set forth by the English colonies of North America. So if there were English colonies and the people who came to land these colonies were not English people, they were British subjects, all right, immigrants, if they were English colonies. That means there were people, where were the English people here who allowed colonies to be set up for immigrants coming here. But as you can see, the dominant language here in the Anglosphere is English. But there are no English people here. There are only immigrants, as Biden just said. This page focused on the rules pertaining to bastardy that became law in New England colonies of Massachusetts, Connecticut, and Pennsylvania from the early 17th century to the late 18th century. The colonies established many laws based on the combination of Old English common law and their religious faith. European settlers established rules to guide society upon their arrival to North America. Many of these rules strongly resemble established guidelines set forth by England. Although the laws differed initially in their creation and enforcement, by the late 18th century, the New England colonies and colonies of Pennsylvania had altered their laws pertaining to the bastardry to mirror images of the laws in effect of England. So if that's the case, let's go to England and Wales laws. All right. A bastard, also historically called whoreson, although both of these terms have largely dropped from common usage. In the laws of England and Wales, is an illegitimate child, that is, one whose parents were not married at the time of his or her birth. Unlike in many other system laws, there was previously no possibly a post factum legitimization of a bastard. This situation was changed in 1296. Was an illegitimate child. The difference is the traditional Western common law and the status of a child born to parents who are legally married to each other, and of a child conceived before the parents obtain a legal divorce. Conversely, illegitimacy, also known as bastardy, has been the status of a child born outside of marriage, such as a child being known as a bastard, a love child, a natural child, or illegitimate. In Scottish law, the term natural son or natural daughter carry the same implications. Under English law, a bastard could not inherit real property, could not be legitimized by the subsequent marriage of a father to mother. There was one exception when his father subsequently married his mother and the older illegitimate son, a bastard in, took possession of his father's land after his death. He would pass the land on to his own heirs on his death, as in the possession of the land had been retroactively converted into true ownership. A younger non-bastard brother, a malleable person, would have no claim to the land. That takes you into what we call time immemorial. I've seen this term stated many times. Time immemorial is a phrase meaning time extended beyond reach of memory, record, or tradition, and definitely ancient. Ancient beyond memory or record. You know that your ancestors were here, and the records goes back beyond their records. If you can't prove your records go back beyond your records, then you're subject to their record. All right. He who writes your book sets your timeline. So in our timeline, according to our laws, according to our books, in regard to how we perceive time and more, not based on abstract but concrete, in law, time and more denotes a period of time beyond which legal memory cannot go. So our legal memories cannot go because we don't study. So it becomes time out of mind, which is the most frequently the phrase time immemorial appears as a legal term of art and to judicial discussions of common law developed in the United States and concerning the property rights of Native Americans. We know that Native Americans, according to the royal title of the crown, which is only a temporary title, it's temporary. All right. So if it's temporary, then that means that it's a time when it can be taken away from you. And the only way it can be taken from you is those who can prove they had it longer. That's under what we call prescription. Laws under prescription. Time memorial is frequently used to describe the time required for a custom to mature into common law. Medieval historians describe this as the watershed between the primary oral culture and a world where writing was paramount. Common law is a body of law identified by judges on judicial proceedings rather than created by legislators. Judges determine the common law by pinpointing the legal principles consistently reiterating in previous legal cases over long periods of time. That's called stereotyping. In English law, time immemorial ends and legal memory begins in 1189. Did you hear that? In English law, time immemorial ends, i.e., customary usage, as a result of you're not using the law anymore. They're not using the common law of England, yet it's still here. They got the language. The law is still here. I'm reading it to you. But yet, we're the people who's supposed to be practicing. This becomes the problem. Why? Because time immemorial, as pertaining to you, goes back prior to that, which you can't improve. All right? They didn't have English names back then. Because common law is founded to have a non-historical immemorial event, it is distinct from laws created by a minor or legislative body on a fixed date. In English law, listen, time immemorial have also been used to specify the time required to establish a prescriptive right. All right? Prescriptive right. American law inherited the English common law tradition. You hear that? American law inherited the common law tradition. So American inherited common law tradition. That means all the inheritances of that which is protected by law here in America is protected under the English common law. And that's the only way that English common law gives you the ability to have the prescriptive right. What is prescriptive right? I don't understand. Easement. All right. Remember, the properties now, as we've shown, and the state represented by Attorney General Parsons against the corporations, Standard Oil Company owned by the Rockefellers, if property is left in its street as a result of interstate, it automatically goes back to the crown, right? If the crown is not in possession, then it must fall under bona vacatina, which means unclaimed property, which the United States takes under, or the states takes. It's called unclaimed property, which results in it being given out by what we call easements. An easement is a non-possessory right to use or to enter into real property of another without actually possessing it. You hear that? So this is what they use. Everybody who is using or owning or occupying property now today is by way of what we call easement. And an easement is a non-possessory right as a result of the prescription by easement by the so-called claimant sovereign, i.e. the United States. The United States is not sovereign. We already proved they're not sovereign. What is a non-possessory right for those who need more clarity? A non-possessory interest in land is a term of law property to describe any of the categories of rights held by one person to use land that is the possession of another. Such rights can generally be created in one or two ways, either by express agreement between the parties who own the land and the party who seeks to own interest, or by any order of the court. Most of the issues dealing with personal property is ordered by the courts under what we call chancery. You know, chancery deals with probate. Probate means to prove. All right, and children fall under the laws of probate court. So in the case of probate court, under Part 2, Secretary, the property of the children fall under the authority of the state at province patriarch, right? We proved it. You know, that has been the case until this present day. Even immigrants who come over here is protected by their father. It ain't their mother country. It ain't their personal father. Why? Because you see children coming over here across the border by themselves. Where's the parents? Nowhere to be found. Somebody has to deal with this issue. Why? The only person that can deal with this issue is their mother country. The mother country in which the immigrants are coming here is not England, because they're not English people. And as a result of that, it's a problem. Let's prove it. Case law. Barbers versus Barber. If I see this, Barbers versus Barber, 1951 case. The conception of equity inherent original jurisdiction as part of its general jurisprudence over the persons and estates of infants has general acceptance. While this jurisdiction may, in its very exception, have belonged to the king as part of his executive power, as provides patriarch to protect his subjects, and may by him have been transferred to the court of chancery. Did y'all hear what I just said? Did you hear what I just said? Is a firm established as a judicial function of the court. It does not belong to the chancellor alone as the personal delegate and representative of the crown. It is exercised by all the judges composing of the court of chancery in the same manner and governed by the same regulation as in all other confessedly judicial functions. It has been suggested that by the ordinance of March 28, 1770, the governor of the province of New Jersey was left with all the jurisdiction held by the English chancellor as a judicial officer, as distinguished from his power as the minister of the king or the representing the king as provincial patriarch. And the original jurisdiction of the courts of chancery did not include the care of property infants as subjects which belonged to the chancellor in England as the provincial patriarch rather than as a court, and was conferred upon the chancellor of New Jersey by statute. So we see, as the King's Bench said in Somerset versus Stewart, and we know the King's Bench is headed by the chancellor. And he said all persons who were born in the king's soil are free, but you're not born on the king's soil as a result who's occupying the soil under what we call prescription of sovereignty. All right, so therefore you fall under the emphasis of the provincial patriarch, which was ruled by those de facto monarchs, i.e. the House of Stewarts. See Dred Scott versus Sandford for that. But But be that as it may, it was long recognized that the old Court of Chancery had general jurisdiction over the care and custody of infants domiciled or actually residing in New Jersey. Chancery had the beneficent prerogative of the care and protection of infants because of their incapacity for self-protection due to their tender years. The Holmes case, Vice Chancellor Stevenson found that the control of the infant was part of the original general jurisdiction of the courts of chancery, and that while of course laws in regards to infants may be made and changed from time to time, the jurisdiction of the court of chancery to enforce those laws cannot be impaired by the legislative enactment. The jurisdiction of the state to regulate the custody of the infants found within its territory that depend upon the domicile of the parents. Did you hear that? It does not depend upon parental patriarch. It has its origins in the protection that is due to the incompetent or helpless. For this reason of the child suffices, though the domicile be elsewhere. At common law, I repeat, at common law, an illegitimate is deemed nullus filius with few civil rights or privileges. He has no inheritable blood, but he has a right of property. He can have no heirs except of his own body, and if he left no lineal descent, his property is escheated. As I just read in the case law, Parsons versus representing the state against the corporation. The United States is a corporation, the states are a corporation. They have no sovereignty. Blackstone says the acquired rights of an illegitimate have the protection of the common law, and Chancery has the same inherited jurisdiction over dependent illegitimate within the state. For their care and custody and general protection, it has of legitimate children had its origin, which recognized the pre-existing jurisdiction of the court of chancery over the care and custody of illegitimates. This act was a supplement to the act relating to minors, their adoption, custody, and their maintenances, and it was stated to be the declaratory of the existing laws upon the subject. All right, a little further. All right. So in closing, as we can see, so as we see in State versus Parson, and Cody Staffs, the principle was the right to take that which belongs to no one appertaining to the crown as jure regalia. The crown steps in to take the property because it is vacant. Property described as bona vacatina is taken or assumed by the state as its own. So right now, your abandoned property being overseen by the state under bona vacatina as what they call unclaimed property until I come back from you. But I only can recognize you if you're part of my church, because the church is the crown. The crown is owns all intel property, and intel property is inheritable. All right. If you claim to be inheritable by way of descent, then that means that you are part of the inheritable estate overseen under the public trust. Property of this class falls to the crown as a matter of right and is exercise of its sovereign power. In personal estates which are allodial by law, the king is last heir where there is no kin. You hear that? Where there is no kin. Going back to the time immemorial, it says here, if I see this in closing, in English law, time immemorial ends and legal memory begins at 1189 and the end of the reign of King Henry II, who is associated with the invention of the English common law. All those who want to see reference to that, see law in as history, the common law in American politics. Did you hear that? Cunard and Parker. Everybody go get that book. All right. It said, I repeat, in English law, time immemorial ends and legal memory begins. So if you claim to know some type of law in your memory, then they better go to 1189, because if not, it's notwithstanding. The end of the reign of King II, who is associated with the invention. Invention is protected by antitrust law. All right. It's protected by antitrust law because it was held in the public trust by the king. What king? The King Henry II. King Henry II was king of England. So y'all see that. King Henry II was king of England from 1154 until his death. 1189, during his reign, he controlled England, substantial parts of Wales, Ireland, much of France, including Normandy, Aquitaine, and Anjou, an area that was later called Angevin Empire, and also held power over Scotland and the Duchy of Britain. So that means that the House of Plantagenet controlled everything. Did y'all hear that? They control Ireland, Scotland, France, Normandy, Aquitaine, even the Duchess of Brittany, going back to what we call Netherlands. All right. Henry became politically. Henry became politically and militarily involved by the age of 14 in efforts to his mother, Matilda, daughter of Henry I of England, to claim the English throne. And we know that Henry I married Margaret of Scotland, and Margaret of Scotland was the descendant of Edward the Confessor, the son of Ethelred the Unready, the son of our Jesus Christ. So they are family. And we know Henry II father was Godfrey. Let's go to Godfrey in closing. Okay. Godfrey, the fifth count of Anjou, called the handsome fair. Well, no, I'm kind of handsome, so thank you very much. It also says Godfrey married Empress Matilda, King of Empress Matilda, daughter of King Henry I, and Duke of Normandy, led through the son of Henry II to the 300-year reign of the Plantagenet crown. So we know that Empress Matilda was the daughter of Margaret of Scotland, who was the wife of Henry II. All right, and let's just close on the Kings of Wessex just to qualify that. House Somerset. House. House. Are you of my father's house? Are you of my father's house? That's the question you should be asking yourself. As you can see, the House of Wessex, also known as Saxon and West Saxon dynasty, refers to the family traditionally found in Cerdic or Gyz that ruled Wessex in southern England from the early 6th century. The house became dominant in southern England after the ascension of King Ecgbert in 1802. Alfred the Great saved England from Viking conquest, i.e., the uh, uh, Danish Viking conquest in the late 19th century, and his grandson Alcerton became the first king of England in 927. The disastrous reign of Ethelred the Unready, who was the son of Jesus Christ, ended the Danish conquest in 1014. Ethelred and his son Edmund Ironside attempted to resist the Vikings in 1016. After their death, the Danish Knut the Great and his son ruled in 1042. The House of Wessex then briefly gained power under Ethelred's son Edward the Confessor, but lost it after the Confessor's reign with the Norman conquest in 1066. This is when all the immigration started. All right. All the kings of England since Henry II, i.e., son of Godfrey the Count of Anjou, have been descendants from the House of Wessex through Henry I's wife Matilda of Scotland, who was the great granddaughter daughter of Edmund Ironside. Okay. So we know and understand that we are not allowed to escape as a result of the Slave Fugitive Acts that were created through what they call the one of what was that? 1793 and 1850. Slave Fugitive Act of 1793 and the one of 1785. Okay? 1793 and 18, what was that said? 1850. All right? These are the exact result of them trying to hold on to us. You know, we can't escape us because we always subject to what we call bill of attaiндers. And bill of attaiндers are those who committed treason or felony. It's a felony to commit a treason act against your nation. All right. Since they committed treason act against their mother country, all citizens of the United States, now called immigrants, are subject to the same classification, and the only end result is doom. So with that, I end in this marvelous lesson. And I hope that all of you who view this will understand how important it is to actually deal with your citizenship formally. All right. And your citizenship can either be acquired two ways, either the church or the state. You have a choice to make. You know what I'm saying? And I advise you that you must make them soon. With that, I say peace.